everyone, let's talk about stepchildren or step-grandchildren. Oklahoma law does not provide for stepchildren or grandchildren, meaning that unless you have something in writing, your stepchildren will not inherit from your estate. So I have two scenarios for us to talk through today. Let's say we have husband. He has a daughter from a previous marriage, and wife, let's say she has two sons, son 1 and son 2. Husband and wife together, they bought a house as joint tenants with the right of survivorship. Let's say they got together when the kids were all very small and they were all raised together. There was no mentioning ever of any step parent or step kids. So the plan, as everyone sees it, is that they all are to share an equal third when the parents pass. Well, while they thought about it and they talked about it a lot, they never put it in writing. So that when there's nothing in writing, the Oklahoma law dictates what happens to these people's properties. So let's say husband dies first. He is in a terrible car accident and he dies. The house and all the other accounts that are as joint tenants automatically goes to wife. So the house goes to the wife, the bank accounts, whatever pension, retirement investments they have, the spouse, the wife as a first beneficiary, everything goes to the wife. So then let's say what happens when wife dies. Let's say 15 years later she dies. Now, unless she has an estate plan where she included husband's daughter, which for all purposes in her mind, she's her daughter, she's not a stepdaughter, stepdaughter will not inherit. Because as I said, unless you have something in writing, Oklahoma law does not provide for stepchildren. So when wife dies, the kids sell the house, her son 1 and son 2 sell the house, and they don't have to give anything to daughter. Do they want to reach some kind of agreement? Are there some consequences tax-wise or otherwise maybe? But in the eyes of the law, they don't have to give a cent to daughter. So if you want to try to avoid this circumstance, have something in writing. Even if a will have to be probated, at least you can designate in the will your desired distribution. You can include stepchildren or grandchildren. Very quickly, I have another circumstance here. Let's say husband and wife. They're both at their second marriage again, because that's usually when steps come into play. Let's say husband has two sons, son 1, son 2, and wife has no kids. And they all love each other, they all grow together as a happy family. Wife raises sons as her own. But let's say husband dies. So then everything, as we talked about, if it's in joint tenancy, everything goes to the wife. Unless husband specifically has, let's say, his sons listed as beneficiaries on some of the accounts, or unless they have some sort of estate plan that provides that upon husband's death, his sons get a half or a percentage or something, not wife 100%. But if everything is in joint tenancy, the spouse gets everything upon the first death, upon the husband's death. Now let's say wife dies. She meant to put something in writing, she never did, so she has no estate plan, which means the state dictates what happens, the laws. Well, son 1 and son 2 are wife's stepkids, they do not inherit. Who is wife's heirs, even though she has now no spouse, no kids? It'll be her parents, it'll be her siblings, and so on. Will the parents or siblings try to include son 1 and son 2 in the distribution? If they want to, but they don't have to. And this, we may be talking about the family home, where husband and wife raised the two sons, but because wife never legally adopted them, because there's nothing in writing, son 1 and son 2 do not take from the estate. They can lose out, for example, on the family home and all the other investments, unless they are specifically designated as beneficiaries or heirs. I hope this video helped. If you have stepchildren, be sure to have something in writing. If you want to include them, if you want to make sure that when you die or your spouse dies, they'll inherit, they won't be left out, have something in writing. It's that simple. Watch our other educational videos for more information. Visit our website, like our Facebook page, and become a subscriber of our YouTube channel. Thank you for watching.